A unanimous Supreme Court decision just dropped. 9 justices, 0 dissents. And if you carry a firearm in your vehicle, this ruling changes the rules of every single traffic stop you will ever have from this point forward. Here is the part that should stop you cold. Most gun owners will not hear about this for months. Some will not hear about it at all, and a small number of them will find out the hard way. Standing on the shoulder of a road, hands on the hood of their car, wondering why a completely legal firearm just turned a broken tail light stop into the worst night of their lives. That is not going to be you. Not after today. But stay with me because this is not a simple story. There are layers here. There are things this ruling protects and things it absolutely does not. There are moments in a traffic stop where your knowledge of this decision will protect you completely. And there are moments where one wrong word, one wrong move, one wrong assumption will make this ruling entirely useless to you. Before we go any further, make sure you are subscribed. I cover rulings like this one the moment they come down, not weeks later, not after it is already too late. Right now, while you still have time to understand it before you ever need it, hit that button now. Let us get into it. To understand why this ruling matters so much, you have to understand the problem it was trying to solve. The United States Constitution gives you 2 separate and distinct protections that on paper should never conflict with each other. The Second Amendment gives you the right to keep and bear arms. That is settled. That is foundational. Millions of Americans exercise that right every single day, legally, responsibly, without incident. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. No government official can rifle through your car, your home, or your belongings without either a warrant or a very specific legal justification called probable cause. That protection is also foundational. It is one of the bedrock guarantees that separates a free society from a police state. 2 rights, both crystal clear, both constitutionally protected, and for years, they were quietly crashing into each other every single day on roads and highways all across this country. Here is the collision point. When an officer approaches your vehicle during a traffic stop and learns that you have a firearm inside, what does that knowledge legally authorize him to do next? Can he search your vehicle based solely on the presence of that gun? Even if you have done nothing wrong, even if the firearm is perfectly legal, even if there is not a single other reason to suspect criminal activity, some courts were starting to say yes. And that answer was slowly becoming a crisis for every law-abiding gun owner in America. Lower courts were building a doctrine that essentially treated a firearm as a golden ticket for law enforcement. The logic went like this. Guns are inherently dangerous. Therefore, if a gun is present, the situation is inherently unsafe. Therefore, the officer has an automatic right to search the vehicle regardless of whether a crime has been committed. If the mere presence of a legal firearm automatically gave law enforcement grounds to search your vehicle, then exercising your Second Amendment right would simultaneously strip you of your Fourth Amendment right. You would not be able to have both. You would have to choose. Be armed or be protected from unreasonable searches. Pick one. That is not what the Constitution says. That is not what any reasonable reading of the Constitution has ever meant. But it was happening in courtrooms, in real cases, affecting real people. And it was spreading. Cases like this one do not start in the Supreme Court. They start exactly where yours would, on the side of a road. Picture the scene. A driver is stopped for a minor traffic violation, nothing serious, the kind of stop that should last 5 minutes and end with a warning or a small fine. The officer approaches the window. During the interaction, it comes out that the driver has a firearm in the vehicle. He discloses it calmly. He is cooperative. His hands are visible. He is not acting erratic or nervous in any unusual way. He has done nothing that a reasonable person would look at and say, that is suspicious. But the officer makes a decision. He decides that the gun itself is enough. That the presence of a firearm creates an automatic safety concern that justifies a full search of the vehicle. No warrant, no additional probable cause, no specific articulable facts pointing to a crime being committed, just the gun. The driver objects. The search happens anyway. The case winds through the lower courts. And here is the part that should genuinely disturb you. The lower courts side with the officer. They rule that, under the circumstances, the presence of a firearm alone was sufficient justification for the search. They basically said that being a gun owner makes you suspicious enough to lose your privacy, one constitutional right used as a reason to override another. Then it reaches the Supreme Court of the United States. And what happened in that chamber is something that almost never happens in American law. 9 justices representing every ideological corner of that bench, from the most conservative to the most liberal, looked at this situation and arrived at the exact same conclusion. 9-0. No splits, no partial concurrences on narrow grounds, no dissents. A complete unified across-the-board ruling. When the Supreme Court agrees 9-0 on anything involving firearms and law enforcement authority, you pay attention because that level of agreement does not happen by accident. It signals that the constitutional boundary being drawn is not subtle. It is not ambiguous. It is clear enough that 9 very different legal minds all landed in the same place. Here is the core of the ruling, and every word matters. The mere presence of a legally possessed firearm in a vehicle does not by itself constitute probable cause to search that vehicle. Read that again. Legal gun ownership is not suspicious activity. Lawful carry is not evidence of a crime. Law enforcement cannot treat it as such. The court told departments across the country directly and unambiguously that you cannot use a citizen's exercise of one constitutional right as the justification to strip them of another. You cannot use the Second Amendment against the Fourth Amendment. Those rights exist together. They stand together, and a law-abiding gun owner is entitled to both simultaneously. The justices reminded the government directly, armed does not mean criminal. 9-0. Now, here is where I have to slow you down. I know what some of you are thinking. You are thinking this ruling is a shield, a force field, that the next time an officer approaches your window, you have a 9-0 Supreme Court decision protecting you. And that is the end of the story. It is not the end of the story. And if you treat it like it is, this ruling will not protect you. It might actually make things worse. The court ruled that a legal firearm by itself does not create probable cause. The critical phrase there is by itself. The moment other factors enter that stop, the entire legal analysis changes, and changes fast. There are 3 specific trapdoors you need to understand cold, because these are exactly what law enforcement will use to get around your rights, even after this ruling. The first trapdoor is about who this protection actually covers. This ruling protects lawful gun owners. It does not protect prohibited persons. If you are legally barred from possessing a firearm due to a felony conviction, a domestic violence restraining order, or any other disqualifying factor, the 9-0 ruling does not apply to you. If the officer has a reasonable suspicion that the gun is not legal, the presence of that firearm stops being an innocent detail and becomes potential evidence of a crime. The shield only works when your house is completely in order. The second trapdoor involves storage. Many states have specific laws governing how a firearm must be stored in a vehicle. Some require it to be unloaded. Some require a locked container. Some restrict where in the vehicle it can be located. If an officer approaches your window and sees a firearm stored in direct violation of state law, the 9-0 ruling will not save you. In that moment, the officer is not searching because you have a gun. He is searching because he has articulable facts suggesting a criminal violation of a storage statute. The gun alone was not the issue. The unlawful manner of possession was. This is where many responsible, well-intentioned gun owners get tripped up, and it is entirely avoidable with a few minutes of preparation before you ever put the car in drive. The third trapdoor is the catch-all that officers use most often. While the gun itself is not probable cause, it can absolutely be part of a broader picture. Imagine you were pulled over with a legal firearm, but you also have a passenger acting extremely nervous. There's a faint odor of a controlled substance in the air, and you're given Court did not abolish the automobile exception to the Fourth Amendment. What officers cannot do anymore is use the gun So, he tries to get you to hand him permission voluntarily. He might say it exactly like this. Since you have a firearm there for my safety and yours, do you mind if I just take a quick look through the car? He sounds reasonable. He sounds like he is doing his job. And your instinct as a law-abiding citizen is to cooperate. You want to show him you have nothing to hide. Do not take the bait. The moment you say yes or sure or go ahead, the 920 Supreme Court ruling becomes completely irrelevant. You have handed the officer a blank check to go through your glove box, your trunk, your personal bags. Understand this clearly. Consent overrides the court. If you give it, you cannot take it back in a courtroom. So, let us talk about exactly what you do from the moment those lights come on. Pull over safely and promptly. Do not make the officer wonder if you are trying to flee or stall. Turn off the engine. Roll down your driver's side window all the way. And if your windows are tinted, roll down the rear windows, too. This removes the fear of the unknown for the approaching officer. If it is dark, turn on your interior dome light. Then place both hands flat on top of the steering wheel and keep them there. Do not reach for your registration. Do not reach for your wallet. Stay still until the officer is at your window. A significant number of traffic stop escalations have nothing to do with legal arguments. They have to do with an officer who is uncertain about what the person in the vehicle is doing. Uncertainty breeds tension. Tension breeds decisions you do not want made at your window. Remove the uncertainty before the officer reaches your door. When the officer asks for your license and registration, do not reach for anything yet. If your firearm is near where your documents are stored, a sudden movement toward that area without warning is exactly how calm stops become dangerous ones. Speak first. Say clearly and calmly, "Officer, my registration is in the glove box, and I want to let you know I am legally carrying a firearm. How would you like me to proceed?" That single sentence does three things at once. It demonstrates full cooperation. It removes surprise from the equation. And by asking how they would like you to proceed, you put the ball in their court. You are showing that you are not a threat. You are a law-abiding citizen following a process. And most officers recognize that immediately. Know your state's disclosure laws before you ever put the car in drive. Some states legally require you to inform an officer immediately that you are carrying. Others have no such requirement. If your state requires disclosure, comply immediately and calmly. If it does not, and the firearm is not visible, you are under no legal obligation to volunteer that information unless directly asked. But if you are asked directly, never lie. A single lie to an officer can turn a completely routine stop into a criminal situation faster than almost anything else that could happen at that window. Then comes the moment that defines the entire stop. The officer says, "Do you mind if I take a look inside your vehicle?" This is where your rights either protect you or fail you. You say calmly and without any hostility, "Officer, I respect the work you do, but I do not consent to any searches of my person or my vehicle." That is it. No lecture. No constitutional debate. No referencing the Supreme Court ruling. You are not on the side of the highway to win an argument. You're there to protect your legal position so you can win later in a courtroom with an attorney beside you. If the officer responds with the classic line, "If you have nothing to hide, why not just let me look?" Recognize that for exactly what it is, psychological pressure. It is designed to make refusal feel like guilt. You respond calmly, "I am exercising my Fourth Amendment rights, and I do not consent to a search." And then you stop talking. Silence is a legal tool. Use it. Do not fill quiet moments with nervous explanation. Do not volunteer information you were not asked for. Do not answer questions like, "Where are you coming from? Where are you headed? Or is there anything in the car I should know about?" You can politely say, "I prefer not to answer additional questions." Refusing to answer questions is not suspicious in the eyes of the law. Snorts. It is a protected exercise of your Fifth Amendment rights. Most people try to talk their way out of a search and end up providing exactly the information an officer needs to build probable cause against them. Your conversation gives the officer the building blocks he needs. Silence removes every one of those blocks from the table entirely. There's also a legal distinction worth knowing about officer safety. Courts have long allowed officers to conduct what is known as a Terry stop, asking you to step out of the vehicle for officer safety purposes. This ruling does not necessarily prevent an officer from asking you to step out if he knows a gun is present. What it stops is the expansion of that safety check into a full search of your vehicle's interior. Some officers will try to blur that line. They will say, "For my safety, I'm going to need to check the area within your reach." Before this ruling, they got away with that almost every time, because no court wanted to second-guess an officer's stated safety concern. Now, they have to prove there was a specific, articulable, concrete threat, not just the abstract presence of a firearm that happens to be legal. That distinction is where this ruling does its heaviest lifting for you in the real world. If an officer proceeds to search your vehicle after you have clearly refused consent, do not physically interfere. State clearly loud enough for a body camera to capture. I am not resisting, but I do not consent to this search. Then, let the officer's actions speak for themselves. Every step taken after an unlawful escalation is now under legal scrutiny. Every piece of evidence discovered in a search that should not have happened becomes potentially suppressible in court. Your composure at that moment is not weakness. It is the foundation of your entire legal case. The moment the stop is over, document everything before you have driven 5 miles from that location. The time, the place, the officer's name and badge number, the exact words exchanged, whether you consented or refused, and what justification was given. Memory degrades faster than people expect. Specific details are what attorneys use to win cases. One final layer that almost nobody covers, and it could expose you without warning if you travel. This ruling strengthens your Fourth Amendment protections nationally, but it does not create a uniform gun law across all 50 states. Every state has its own rules on concealed carry, permit requirements, reciprocity, storage regulations, and duty to inform obligations. The moment you cross a state line, your legal status can change completely. A carry permit valid in your home state may not be recognized in the next. A firearm stored legally at home may violate storage laws somewhere else. If you drive from a constitutional carry state into a state requiring firearms to be in a locked container and your gun is under your seat, the officer now has real probable cause, and the 920 ruling will not help you. Researching the laws of every state you pass through is not optional if you travel with a firearm. Use an app, check State Department of Public Safety websites, know the storage requirements, and understand where your permit is and is not recognized. This ruling protects lawful possession. It clears throat cannot and has never protected unlawful possession, and ignorance of state-specific law has never been a constitutional defense. That did not change today. The Supreme Court just handed law-abiding gun owners one of the most significant constitutional affirmations in recent memory. 9 justices, no exceptions, told the government and every law enforcement agency in this country that you do not have to choose between your Second Amendment rights and your Fourth Amendment protections. You are entitled to both at the same time, without condition. But rights on paper require people who know how to exercise them correctly in the real world. This ruling only protects people whose possession is lawful. It only works in a courtroom if the roadside encounter was handled correctly. It only becomes a shield if you did not hand the officer a sword by consenting by lying, by reaching unexpectedly, or by letting panic make your decisions for you. Think about the practical weight of that statement. In states with constitutional carry, adults can legally carry without any permit at all. In states with shall-issue permit systems, millions of people go through background checks, training requirements, and application processes specifically so they can carry lawfully. These are not threats. These are not criminals. These are Americans exercising a right the Constitution explicitly protects. This ruling affirms that those people should never have to surrender their dignity or their privacy simply because they made that choice. The court drew the line clearly. The armed citizen and the criminal suspect are not the same thing, and the government may not treat them as such. So, here is what you carry with you from this moment forward. Calm hands when you stop. Clear communication when the officer approaches. No sudden movements. No voluntary consent. No roadside constitutional arguments. Know your state's carry laws inside and out. Understand reciprocity if you cross state lines. Store your firearm according to the requirements of wherever you are standing. Maintain valid permits wherever they are required. Because if your possession becomes unlawful for any reason, the protection this ruling provides disappears entirely. And no amount of Supreme Court history will bring it back in that moment. Most people who carry a firearm will never hear a breakdown like this one. They will learn about their rights after something has already gone wrong, after the search, after the charges, after it's too late to go back and handle the stop the way it should have been handled. You are not that person. You paid attention. You put in the time before something went wrong. The next time those lights flash in your rearview mirror, you will know exactly what to do and exactly what not to do. Stay informed, stay calm, stay lawful. Because in this country, rights are most powerful in the hands of people who understand exactly how to use.